And thank you for joining us for the next SLW Institute webinar, Generative AI and Intellectual Property Practice. A recording of the webinar and the slides will be made available to all registrants. I will put a link into the chat with a link to the slides, and the slides are posted on our website. Feel free to type questions into the Q&A, and we will try our best to get to your question at the end. We invite you to follow us on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our moderator.
Thanks, Michelle, for the opening remarks. And hi, everyone, and welcome to the webinar. My name is Tyler Nasidlak. I'm a principal in Schwegman's Minneapolis office. And today I'll be lightly moderating this panel. With me is Steve Lundberg. Steve is one of our founders and our Chief Innovation Officer. And I can honestly say in my 30 years of practice, I have not come across another attorney more creative and innovative than Steve as it concerns the legal practice. So I'm very happy to have Steve with us. Andre Murray. Andre is one of our managing principals. He's located in California and has been really wonderful and instrumental in bringing in and evaluating vendor AI tools for us to use in our practice here. Anup Suresh, Anup's a principal out of California. He's our director of compliance and super knowledgeable about client compliance and security risks facing law firms. And then finally, we have three really extremely talented attorneys that go really deep with technical expertise on generative AI. And they are Lucas Jelly, Anna Maria Popescu, and Alexis Listro. I know I, for one, in preparing for this webinar, learned a lot from them and the other panelists. So I'm hoping you do as well. Next slide. So before we get into this, we have only one polling question, and it's a really easy one, but we'd love it if you could quickly answer this. We'd like to know, do you regularly use generative AI in your job? And we'll give everyone just a few moments to hopefully answer yes or no. You can choose not telling you as well. And Michelle, I don't know when you're starting to see enough of the kind of responses come in or not.
Sure, the answers are pouring in. Right now, we have almost everybody having answered, so I'll give it just a few more moments.
And not regularly, what we'll say is a no.
And I will go ahead and end the poll. And then now I'll share the results.
Okay, so about roughly 20% use it regularly. I wasn't quite sure what to expect. I guess that's probably about what I was, if I had to guess, that's probably in the range of what I was thinking. I do think if we did that poll a year from now, that number is going to be quite a bit higher. So thank you. I think we can move on to the next slide. So content for today, we're going to start with some background on generative AI so everyone has sort of a common understanding. And then we'll talk about some of the compliance and security risks using the technology. We'll probably spend the bulk of the time on use cases and kind of what we've seen that works well and what we've seen that doesn't work well, primarily from a patent perspective. And then we'll wrap up time permitting, and we'll talk through some guardrails that you might want to consider for your clients or your companies at the end. And so with that, Lucas and Anna Maria, could you start by providing an overview of generative AI technology?
Sure. Thank you, Tyler. Thanks, everyone, for joining. If we go to the next slide, we're going to start by talking about what exactly is generative AI. And we're going to do this. First, we're going to give some examples of generative AI models, and then a general introduction to to the models, specifically focusing on the transformer models that are the basis of some of the popular large language models that you might have heard of, like GPT-3, GPT-4. We're going to talk about GPTs as vector spaces. We're going to give some intuition as to how much these models know, and then how they are trained and how they are fine-tuned for very specific tasks. And then we're going to end with the development cycle for generative AI. If we go to the next slide. So there are many types of generative AI models. This slide and the next one showcase examples of models that take one modality of input, such as text, and then produce a different modality, such as, for example, image. Some of the models that you may be familiar with are DALL-E models, they're sort of text-to-image generation models. There are, of course, just text-to-text models. So a model that takes a particular type of text and it analyzes it or produces a new output based on it. There are, of course, text-to-video models, text-to-audio, text-to-motion, and so forth. If you go to the next slide. Even though the text input is very common, there are models that can take a different kind of modality, such as, for example, audio input, and provide text output, or, for example, like the audio-to-audio models, they map between two different kinds of audio. And there are, of course, image description models. So you feed it an image and it produces a text description or some kind of text output analysis. And some of the more sort of interesting, and I think maybe not as easy to build models are some of these speech from brain, so the brain to text models. This pertains to the area of analyzing a recording of brain waves in a non-invasive way. And there are, of course, multimodal models as well. If we go to the next slide. I'm going to hand it over to Lucas to go over this.
Hello, everyone. This in the next few slides will be a quick high-level introduction to generative AI and LLMs in particular. Generative AI at a high level refers to AI that can generate new content. As Anna mentioned, this could include generation of text, image, or music. This is all generated without the human actually generating it. The human just provides the prompt. And this generative AI mimics human creativity and mimics problem solving, but it does so by learning these statistical patterns from these vast data sets that we provide as inputs to train each of these models. We'll get into a little bit more of the models as statistical patterns here in the next slide. But the takeaway is that each of these is based on a large statistical model, and it's not actually able to perform any of its own creativity or problem solving. A subset of these GenAI models is generative pre-trained transformers, which we've heard about. ChatGPT and other GPTs are a subset that use a specific architecture, a transformer architecture, and typically apply that to natural language processing, just taking text as input, probably generating text as output, referred to often as natural language processing, NLP. These GPT models are all pre-trained on very large data sets to generate the model itself. And then they may be fine-tuned for specific tasks, such as interacting with the model using a chat interface. So you can type something to it and then provide a meaningful output without you actually having to code anything. You can just interact as if it were another chatbot. LLMs are a specific version of these ChatGPT models. These LLMs capture these statistical relationships between words, and they store this information in their model, and they use that to generate the output. Each of these LLMs may be used for various generative or transformative language tasks. Anna mentioned in the previous slides the types of language output and other outputs that you can generate from each of these. Next slide, please. So this is a high-level overview of a way of thinking of generative AI and LLMs as vector spaces. We don't have to understand the details of the mathematics behind this, but this gives us an intuition about how the models are storing information and then how they're using that stored information to provide an output to you. Each of these LLMs uses a vector space to store and manipulate words. The parameters they include these vectors that represent numerical relationships between words. The phrase you'll read about sometimes is that these are the weights and biases within the neural network, but it's this vector representation that is connected to each word. So each word or token is associated with a unique vector, also referred to as a word embedding, and the collection of those vectors forms the model itself. So the model captures this, all these vectors together and stores that for later use. By storing it as a large vector space, it provides this mathematical framework both for storage of the information and for manipulation and output of information. So, for example, here it enables this, this example vector operation. If you take the concept of the word king and you subtract the concept of the word man, add the concept of a woman, that may equal or result in the concept of the word queen. That's a bit of an oversimplification, but the idea here is to give you some intuition about how we can connect how these words relate to each other in our minds, and how the LLM can use this mathematical framework and perform just vector addition and subtraction to provide the output. That provides the output of a vector that's associated with the word queen, and hopefully that's the output you were looking for. These vectors, similar words have similar vectors. Some words are often connected to each other, or appear next to each other in language. And the training process of an LLM adjusts these vectors based on that context, based on how often the words appear next to each other and how often sentences tend to appear next to each other. So this is the training process, which results in that large LLM and all the information it stores. It's important to keep in mind that LLMs have no concept of grammar or any other rule of language. They don't know how language should work. They can't self-correct. There's no autocorrect feature in it. They're just a very large statistical model that's trained on a huge amount of training data. They generate their output based on this statistical model, and they do so by analyzing the statistical regularities in the model and generating a most likely output. So that's to help you get an intuition about how they generate information, but also to convey that the output of the model is only going to be as good as what you use to train it. So if your language is generally follows grammar and other rules of language, then your output will be mostly correct. But it's your output is only going to be as good as your training data. Next slide, please. So this is a high-level conceptual overview of how the amount of knowledge we have as humans compares to the amount of knowledge retained in any one of these, any given model. And here I just chose GPT-3 as an example. The average human reads about 300 million words in a lifetime. There are about 1.75 billion parameters in GPT-3, the model itself. The parameters doesn't exactly map one-to-one to number of words, but this is to give you an idea of how much more information GPT-3 stores than an average human can store. And GPT-3, of course, has instant access to all that information and almost instant recall and the ability to generate an output in real time using that information. If you compare GPT-3 to GPT-4, there's about 3 orders of magnitude. It's about 1.75 trillion parameters within GPT-4. Estimates are that each LLM is trained on about 20 times that, so about 35 trillion parameters used to train GPT-4. And again, it has instant access to and recall from all of that information. So these training data sets are almost unfathomably large, which is how it's able to generate text that seems like it's generated by a human, but it's just because it's using so much input training data. And with that, I'll hand it back over to Anna.
So if we go to the next slide, I have just a few more details about how these models are trained. Usually the models that you might have heard of, GPT-3, GPT-4, are trained in stages. There is usually a very large pre-trained base model. And the way that that's trained is by feeding the model a very large amount of trained data, as Lucas was mentioning. The table on the slide is from the GPT-3 white paper that OpenAI put out. So it's built based on the information that they provided. You can see that they use a very large training corpus, including web text. The common crawl is just a web text corpus. They use book corpora that are available on the web. Some of the very good content comes from textbooks. Of course, there aren't as many as those. So many of the books included in the training data are, fiction, for example. They can also use other training data, such as code. And this is just, of course, there's also Wikipedia in there. The diversity of this large initial training set makes it so that the model acquires sort of a general knowledge about many different kinds of domains. The model can be one neural network that is trained at once, or the neural network can be seen as a mixture of its layers. Each layer can be seen as an expert. So at different times in the training, different layers will be optimized for different purposes. The way that the model is trained is, as Lucas was hinting at, by looking at this training data and learning how to complete a sequence of tokens. The tokens can be words, for example. So the model will look at a partial sentence and will observe how the sentence is usually completed in its training data. So it will learn reasonable, appropriate ways of completing a set of words. It could be a set of words. It could also be a set of instructions in a programming language if it's learning from code data and so forth. So this is how the model is able to, when you query it as a user, take a prompt, which is the query that you give it, and then provide what looks like a reasonable answer, because it is taking into account the regularities that it has been exposed to in its training data to be able to complete the prompt that you give it in a reasonable way. Of course, generating this large pre-trained model may make it so that it has knowledge across a broad number of domains, but the knowledge might be relatively shallow and it may not be particularly suited to answering questions well or processing documents well in any given domain. So for that purpose, there's usually one or more fine-tuning steps that happen afterwards. For example, if you take a model that was trained on web text, but now you want the model to do very well on analyzing legal data, one thing that you may want to do is retrain the model only partially, only the last couple of layers, for example, with data from that particular domain. So you feed the model new data from the legal domain. The other way to fine-tune a model is to, while it's being trained the first place, provide it with information as to what is expected of it from the point of view of the user. So you can, the way that OpenAI does this is by compensating people. So they pay people to rank the outputs of the system as it is being trained, and according to standard that OpenAI provides, and decide whether a particular set of outputs is good or bad, or how they rank compared to one another. And that information is then used to build another automated model that will capture the average laborer's preference for a given output. So in this way, this model can be used as part of the training itself to guide the computation of the weights that Lucas was alluding to. This will make it so that the model that is being trained will refuse to answer certain prompts. It will be more likely to give good answers to sensitive prompts, such as those in the medical domain, legal domain, business domain. We go to the next slide. This is a slide that corresponds to where we are, according to Gartner, where we are in the AI hype cycle in 2023. The slide looks at, there are these points that Gartner has identified, having to do with where, given a particular invention or innovation, where we are with respect to the time of development from the point of view of people's expectations, right? So for generative AI, we seem to be, according to their opinion, that we seem to be at the peak of inflated expectations because there has been a lot of promise, there has been a lot of hype around these innovations. However, as people are deploying them in practice, we're starting to come across some of the shortcomings or some of the mismatch between what people think that these models can do and what they can actually do in practice for specific use cases. And the next step after the peak of inflated expectations, the next point of the graph is actually the trough of disillusionment. The idea is that once you go through this period of perhaps being a bit disillusioned as to what the models can do, you're learning how to use them and you're learning what use cases they may be suitable for. And then you might be hitting the slope of enlightenment and coming to the other side on what's called the plateau of productivity. And of course, this slide is just to inject some sort of levity and perspective into a period of adaptation to what seems like a lot of new, but also untested innovation. So if you go to the next slide, this is an example of the change between the peak of inflated expectations at the top and the trough of disillusionment at the bottom. And this is this image was generated by DALL-E 3. So Andre, who's one of the panelists, generated this using DALL-E 3. So you can see this is kind of where we are. We're sort of hitting towards this trough of disillusionment, but hopefully we can come out the other side. Go to the next slide. Overall, the generative AI models, and specifically large language models, which are probably the most relevant to the legal domain, have many, many strengths. So there's a reason to invest in understanding them. For example, they provide off-the-shelf natural language processing functionality that used to be perhaps not as high quality before, but more importantly, you had to have different kinds of model for different kinds of tasks. Whereas in this case, these new models provide an integrated functionality. They provide sentiment analysis, summarizing documents, answering questions, and so forth, all as part of the same sort of models. Additionally, if you're using them to generate output, you've observed that their output is coherent and is realistic. So it is better quality than some of the models that we've seen before. Of course, they have many weaknesses, and this is where I think disillusionment may be coming from. One of the main weaknesses is the presence of hallucinations. So hallucinations are invented, incorrect, non-factual content. For example, for the patent domain, they can be in the form of claims that a model may suggest based on a specification that look right, but they are in fact not fully supported by the specification's technical content. Similarly, you may ask a model to summarize a document, and it looks reasonably okay, but then when you look at it, it's not exactly technically correct or supported by the specification. One of the more, I think, distressing and jarring hallucinations that I particularly have seen is if you ask a model whether it is familiar with a patent in a particular area, it will say yes, and sometimes it will just invent a very reasonable sounding patent with a great title and a great ID number, but it's not actually real. It doesn't exist. In addition to the hallucinations, but related to them, the models have limited reasoning or self-correction the way that we think about it. So the arguments or claims that you may get out of a model may be inconsistent. And if you ask the model to revise them, it will do so, but in a way that, again, does not provide a consistent, internally consistent or coherent output. There are some other problems that these models can have. Maybe that I haven't seen them as much in the particular tools that we've been experimenting with, but they are known to provide harmful content. And importantly, you would want to keep the model from inadvertently disclosing information that should be protected or sensitive and exposing that as part of a question answering session. And with that, we're going to move to, if you go to the next slide.
Yeah, I think up next is Anoop, and I think your last comment on some of the weaknesses about disclosing confidential information is a nice segue to this topic. So Anoop, can you jump in and share some of your concerns from a security perspective?
Sure, Tyler. Thanks. Welcome everyone. At present, the Gen AI tools that we have available for, general users, legal professionals are either off the shelf, internally developed, or jointly developed with outside parties. The general structure of these tools are you have an AI third-party tool provider usually and the tool is powered by a third-party model that's been hosted by, say, OpenAI, Microsoft, Amazon, or Google. Regardless of the tool source, here is a high-level list of some generative AI specific considerations that should be, reviewed or taken into account when using this technology. Starting with data security. When using third-party tool providers, it's important to know who at the AI tool provider actually has access to your input and output data, and under what conditions. Is it, only under conditions where it's necessary, or will they provide prior notice before actually looking at or reviewing any of the data that's being inputted or outputted to the tool? It's important to consider data retention policies for the AI tool provider and maybe even the hosted model. How long is your data actually retained? After termination of service, when is it deleted? Um, you know, Many of these tools actually have like sessions for a given user or between users. When you delete one of these sessions, when is the data actually removed from the system? Might be important, not just from your standpoint, but from a law firm standpoint. The clients want to know when their data is being stored outside of the firm, or with certain tools, and what their policies are about deleting such data upon end of use. One should also consider data isolation. Specifically, a lot of these tools have, and the models actually have context information, which is made up of uploaded documents, your input, your outputs, and that's what the model basically generates its outputs based on. And how is that being isolated between sessions, not just across for a given user, but like across different users and maybe even organizations, especially where a third-party tool provider is providing this tool to a number of organizations, different law firms. That's, for example. Is there isolation between different sessions for a user? It's important that, basically when a user is using these tools, that there's no cross-client data leakage between sessions. Is it isolated between users would be important from an ethical wall standpoint. And of course, isolation between organizations is important just to keep confidences of your client. Make sure there's no leakage between outside parties. One should consider encryption as typical of all software tools. Encryption of data at rest, which is stored data, and then encryption of data that's in transit being communicated, especially between a user and the AI tool provider, but also between the AI tool provider and any hosted model services that they may be using to power their tool. Lastly, from a data security standpoint, does the tool or the GenAI provider perform penetration tests, vulnerability assessments, etc.? Do they have or are working towards any security certifications? Some of these things, if they just have those in place, could allay fears or risks when using these tools. Another important consideration is just having knowledge about what foundation models are being used by a given tool. As noted, Gen AI models are usually powered by third parties and built and trained by third parties, and then hosted and used by AI tool providers to power their tools. It's important to know this information, like what models are being used, what the architecture is, from a potentially exposure of data from a breach standpoint. But it's also important to know and confirm that they're not using basically your inputs and your outputs for training data. The training data, it's also important to know what the training data actually is made of, what the sources of the training data are from a biases standpoint, from a copyright exposure standpoint, even a future regulation standpoint from different jurisdictions. There's also the general importance of knowing what the cutoff date for some of this training data is, so you sort of know the limitations of what the model what limitations may exist with respect to the models. knowing what models are being used also gives you an idea about the level of accuracy, the strengths and weaknesses that Anna Marie kind of touched on. And from an export control standpoint, it's kind of important to know not just where the AI tool provider is located and where their services are being performed geographically, but also where the GenAI models are actually being hosted geographically. From a data retention policy, specifically with respect to the models, many of the model providers, they retain some data, at least in their policy, according to their policies, retain some data for abuse and monitoring purposes, usually for 30 days, while some others actually are coming out and saying they have a 0-day retention policy. Usually those are reserved for special arrangements, maybe between the model provider and the AI tool provider, and sometimes it's just reserved for paying users or paying enterprise users. So that's important to check on. Regardless, it's important to inquire about what sort of data retention agreements and data processing obligations might exist between your AI tool provider and their model provider. With respect to retention of IP ownership of inputs and outputs, obviously everyone wants to retain their IP rights to the info they input into these models and tools, and hopefully retain the rights to the output as well. However, one consideration may also be in the realm of engineered prompts, and as people and more individuals start using these tools, it might be important to retain the copyright ownership of unique prompts that are engineered by you or your organization for use with particular tools. These unique prompts may give you or your organization a competitive advantage in the future. And so you may want to retain rights to those prompts. Regarding personal identifiable information, data, and compliance, I just want to remind everyone that input to AI tools still need to comply with privacy rights and regulations of jurisdictions that might impact your practice. So GDPR, of course, in Europe, California's CCPA, which kind of went into effect this year, and then there's similar privacy regulations either in effect or coming soon from other states such as Virginia, Colorado, Utah, Texas. So even though in the legal realm of like patent law, where we do not really deal with PII data too often, users may inadvertently or maybe even intentionally input PII data into an AI tool, and that would subject the tool to such the regulations that might apply for a given jurisdiction. For example, like say invention disclosure form may have contact information for inventors in there. If that's uploaded, then basically PII data has been submitted to the model or the tool, and basically we would have to adhere to whatever obligations we have there. With respect to ethical obligations, you want to ensure that the use of the AI tool still maintains and meets with your ethical obligations, especially with respect to privilege and attorney-client privilege. So it's kind of important that you have a comprehensive internal use policy with respect to tools. It kind of sets a clear message to the organization and members within regarding the use of generative tools, can outline which indicate which tools are safe to use, and with what data, whether it's public data or client data or organization data. Typically, you can have a listing of tools that have that are safe to use with respect to such data. Whether the organization has provided or vetted such tools, and can provide also a list of tools to completely avoid, which is important again to meeting the ethical obligations and data security obligations that a firm might have. So policies can also describe best practices such as corroborating output to ensure accuracy and to avoid use of unverified output in work product, and can ensure that client preferences with respect to use of tools with respect to their particular data are adhered to. It is also important to actually keep up to date, which is kind of difficult given that we don't have set regulations, but the regulations are coming. And the amount of tools that are coming out on a daily basis is hard to keep up with, but it's important to keep up with that, update yourself and your internal policies over time as the landscape sort of changes. With respect to the regulation, of course, the most recent stuff that's occurred is the European Union passed the AI Act, which is like the first government body to actually come up with the first comprehensive set of regulations for artificial intelligence industry. The act actually requires some generative AI systems based on risk to be reviewed prior to commercial release. President Biden recently signed the executive order in October, which creates new safety and security standards for AI, where some AI companies will need to share safety results with the federal government prior to releasing the tool. Provides consumer privacy protections, such as creating guidelines that can be used to evaluate privacy techniques used in AI, and also develops guidance for federal agencies' use and procurement of AI. And lastly, there was the London AI Summit that just took place, I think, last week, where the future of safety of AI was discussed amongst political leaders and tech leaders. Lastly, it's sort of important to monitor and view your existing tools, not necessarily Gen AI tools, but just other software tools that your organization might be using now. A number of these tool providers are continue to keep innovating, and some of those innovations might rely on generative AI. So it's specifically important to monitor how they may be integrating the use of the generative AI into their tools and features. And at times they may do so with little or no notice. And so it's important to maybe do an annual review, or even at this point, maybe even a quarterly review of tools to just determine what your exposure may be there. Next slide, please. Yeah, so these are some more general concerns for software tools in general with respect to fourth parties. As I mentioned, these AI tool platforms and tools being provided out there, for example, for like patent purposes, are powered by third-party AI model providers. And with that respect, you would want to ensure that there's certain contractual obligations between your AI provider and their third parties, their model providers, with respect to data access, breach reporting, employee data access, and overall data security. One should always remember that whatever access control and security measures you may be having in place for your existing tools that you have now kind of carry over to these tools as well. So should ensure that they meet with your existing security standards and have multi-factor authentication and adequate password policies, or at least enforce adequate password policies. And lastly, want to consider insurance. Of course, not something that everyone wants to consider, but something that should be considered as you start using these tools internally. These insurance carriers sometimes have general requirements, or at least guidance at this point, with respect to use of GenAI. You want to ensure that don't have negative impact on, say, your cybersecurity insurance carriage coverage in any way. And yep, that's basically a very high level list. And with that, I hand it back to Tyler.
Hey, thanks, Anup. That was really thorough overview on that. We're going to turn now to practical use cases, and like I said earlier, mainly focused on patent practice. And then I'll just remind everyone, if you do have any questions, there is a button at the bottom. You can type in your question, and we'll try to get to it at the end. So with that, Andre, can you lead us through this topic?
Yeah, thanks, Tyler, and Anup, thanks for that overview. At the outset, I just want to say that we've been testing a number of the commercially available tools out there. I'll say the good news for everyone is that jobs are, if you're a patent attorney, job is probably safe, not probably going to be taken over by an AI anytime soon. At least that's the conclusion we've come to. As I walk through the use cases as well, I think I'll probably, if you were on the hype cycle, the Gartner hype cycle, maybe drop you somewhat into the trough of disillusionment, but hopefully we can get you up on the the slope of innovation as well. We've just been really trying to figure out how best to use a number of these tools in our practice. We've tested a number of tools that are out there that are commercially available using hypothetical data, and I think have largely come to the conclusion that a lot of the tools out there, while showing definitely a lot of promise, and I think there's going to be a lot of development going on, are probably not quite ready for prime time. Certainly, the promise of single input, single output, I think is a way off. We see some tools where you can upload a disclosure and it'll write a patent specification, and it does write a patent specification, but we're just finding that the quality of that is far below what our attorneys would produce and what our clients would expect. That said, we did actually settle on one solution to develop internally. We engaged a Silicon Valley software firm to develop that with us. So we kind of partnered with them on that. And actually, that solution is going to be made available through Black Hills IP for licensing. The reason we do like it is that we find it provides a lot of flexibility across multiple use cases. We really find we can use it across all of the use cases that I'm going to be discussing now. One thing we do really like about it, and I think Anoop alluded to this in prompts and copyright and prompts, there's a lot of value and a lot of learning in doing good prompts, and this tool enables attorneys or any user, in fact, to create a prompt, share it, and store it. And so we can kind of build up this library of prompts and in fact chained prompts that can be made available within an organization. So this first slide over here, bit of tongue in the cheek. We basically one thing we're telling attorneys in order to provide them some guidance about their interactions with AI is to treat AI as law clerks or junior associates, as depicted in this picture over here, who may possess very impressive intelligence, extensive knowledge, but may at the same time be prone to having a drink of whiskey before 5 p.m. And seem to be some more prone to taking a shot of whiskey given certain tasks, like the one Anna alluded to, where conducting a patent prior art search and asking for a return of patent numbers and abstracts. That definitely drives the AI to drink. Okay, well, moving on to the next slide. This is just kind of an overview slide of the various use cases that we're going to briefly discuss now. Preparation use cases, prosecution use cases, admin workflows, and analyzing prior art and portfolios. Just on the policy there, just emphasizing again on double-clicking on what Anoop said. We have a policy within the firm which really enforces appropriate behavior. We have also really found this, human oversight or human in the loop, as I say, is really crucial to realizing any benefits that AI can produce. So next slide, we're going to move straight into preparation. Again, I think here, as I alluded to before, this promise of uploading some disclosure documents and a patent specification pops out the other end magically, I think is not realistic. But that said, we have found the current tool we have useful in certain particular uses, and we've listed those three here. The first one, and I think this is probably where we find it delivering the most use, is in disclosure preparation. And this is enabling our attorneys to perhaps do a lighter touch with the inventors, take less inventor time, and really kind of get the whole disclosure, invention capture, data capture process done a lot more quickly and easily. So the examples here are processing invention disclosure documents. So by uploading those and asking it, the AI to kind of synthesize those and perform various tasks with that has been particularly helpful. Also, just general attorney education. If in a disclosure document there's some concept you're not aware of, just asking the AI, and a lot of the time it'll really give you a good overview at a level you can understand. So, in that way, equipping attorneys to walk into disclosure meetings a lot more prepared and with, potentially a lot less open but stupid questions that they might need to ask the inventors. Also very useful for generating questions for the attorney to ask the inventors in order to really get enough information for a fully enabled and technically detailed description in the specification. And then finally, as we've alluded to, it's not very good at prior art searching, particularly of patent literature, but it can give a good overview of the art. I think that's where Anna and Lucas's overview of how these things are trained, you'll appreciate over there. It does have a very good general understanding. It's just when you get into identifying a specific document or a specific extract from a document that it really, because it's working on statistical probability, is not very good at that. Then, the second kind of use case here really is as a drafting assistant or co-pilot. Again, it's emphasizing not good at single input output, but rather very much more useful as an iterative process. It does fairly well if as adding, as I've put there, meat to the skeleton or to the bones. If you kind of outline a specification or a description and then have disclosure material and ask it to extract material from the disclosure and add it to that outline, it seems to do a fairly good job over there. Again, you do have to, the prompt engineering over there is very important, and you have to tell the model to really not go beyond the bounds of the disclosure material. So if you, but with sufficient prompt engineering, you can actually get it to do a fairly good job there and curtail its hallucinations and whiskey drinking habits. Also, going through asking for suggestions for language for technical problem solution. Very often we do have, we make an effort to identify technical problems, technical solutions, but having the AI really think about that and give you suggestions as well as proved to be helpful. Conversing between different claim types, so putting in a method claim and asking it to convert that to a system or an apparatus claim can work well, particularly if you, in your prompt, give it an example of the format you want. Suggesting dependent claims, if you've already got a set of dependent claims and want suggestions for additional ones, it seems to do a good job there. And then also, enablement, we found it kind of useful for expanding certain technical descriptions, with well-known techniques and alternatives. So, previously where the attorney may have had to do a lot of research on Wikipedia or just generally doing a lot of reading to figure out, alternatives or how something works to describe it in the specification. Again, with the premise that it needs careful review, we have found it to be useful for that type of content generation. And then the final use case here really is reviewing draft applications for quality and completeness. Again, it'll often spit out a number of bullets that are you can to ignore, but particularly if you're asking it to review for full written description support for the claims and antecedent basis and all that, it actually does a fairly good job of that. Okay, I'm going to quickly move on to the next set of use cases, which is for patent prosecution. Again, uploading a office action and asking it to draft a response, not going to happen. But we have found that there are some use cases, particularly if you structure your prompts correctly, that can be helpful here. We kind of found the best case or best use over here is for the attorney to do an initial review and approach the office action response as you would do in your normal practice. Come up with some thoughts, but then use the AI as a supplementation or assistant to perhaps surface some other arguments or some angles that may not have occurred to you. First use over there that we have in prosecution is summarizing office actions. Again, if you're uploading the document and asking it to stick to what's there, it can actually generate a very nice summary. This is kind of helpful if you need to report something to a client, or, in a certain way. So we haven't done this yet, but I think one potential future use for this is reporting correspondence from patent offices with kind of customizing template letters is probably going to be some low-hanging fruit. The next use over there we have is kind of suggesting arguments, and I've used the word there, suggesting, very specifically and very intentionally. So we found it to be quite good to, or a good use of it is actually to go, give me a list of suggested arguments I could make against a particular rejection, and that allows you to kind of peruse all of those quickly, and apply your mind to identify ones which you'd already thought of, or potentially identify some that you hadn't, and then you could iterate on it. You can actually go, oh, on that particular argument, expand on that, or give me some further thoughts on that, and that can often lead you down a path that you may not have thought of before. So we kind of finding it helpful for that particular use. I think the thing to keep in mind here, particularly for 101 patent eligibility rejections, the AI doesn't have a deep understanding of all the PEG positive examples. But if you upload a summary of the positive examples into the context window for a particular prompt, that can give you quite significantly better results. And the same thing with case law. Again, it does often get stuff right, but it often gets stuff wrong as well. So you need to be very, very careful over there. Looking at 102, 103 rejections, again, if you just upload the office action, the AI often gets confused between language of the claims and quoted sections of the prior art that may be in that office action. So there again, as part of a prompt engineering strategy, we found that much more effective, and we get much better results if we upload the pending claims as a separate document into the context window, and potentially also copies of the references. So this can really reduce confusion in the AI between what is language of your claims versus what is language from the prior art references. Suggesting claim amendments, we found it a lot less helpful over there. It tends to kind of miss the nuances of language that are typically needed. But again, if you ask it to suggest some potential amendment strategies, it does often generate a list that you can kind of peruse and use as a double check for your thinking. Okay, moving on to the next slide, which is analyzing prior art and portfolios. Again, here we found the current generally trained foundation models struggle to deliver usable patent literature search results. There are some specialized tools that have been trained, and as Anna said, with layers that may be very much more fine-tuned to patent literature searching. So we are seeing better results out of those, but those are not generally available. But doing a prior art search on most of the Anthropic or OpenAI models does generate very disappointing results. Also, it doesn't really have the ability to do analyze large portfolios at the moment. The context window of any prompt at the moment is limited. But there are ways to that are being developed to address this. And I think I mentioned the next one, specifically trained or fine-tuned models are showing potential for searching. And even searching portfolios to potentially identify strengths and weaknesses. And then models which have larger context windows or enable prompt chaining solutions. And there are a number of solutions that are under development or to really help with the AI kind of analyze these larger bodies of documents or beyond the current constraints of the context window. So that's something to kind of keep an eye on. Okay, and then the next slide, please. Another thing we've been experimenting with is identifying evidence of use for allowed or issued patents, and also analyzing claims to determine whether they could potentially be standard essential claims. Firstly, on the evidence of use, found it pretty good at identifying potential third-party products to investigate. So if you put a set of claims in and go, hey, give me a list of some products that may potentially have elements corresponding to the limitations of this claim, and rank that in order of how strong you feel about it. It actually does it may generate some products for you to at least go look at. It's when you get into ask it to doing a claim chart or publication dates that it's not very good and starts to hallucinate. And again, understanding how, when Lucas and Anna described how it's trained, it's looking at statistical probabilities. It's not looking at it's not accessing a database per se. So that's just a quick takeaway over there. And then you're basically the same thing when analyzing claims to assess whether they're might be standard essential implicated. Good at flagging ones that may potentially be applicable to a standard, but claim charts does not do a very good job. Okay, and next slide. And I think, Tyler, we hand over here to Steve.
Yeah, Steve, if you can go ahead on this one.
All right, yeah, I'm going to make this quick to save time, but I think when you're using generative AI, if you need to deal in exactitudes, it's not going to be the tool you need. It's tremendous creativity makes it fairly ineffective for something like automated docketing, where it can tend to be inconsistent. So that's like a use you wouldn't want to use it for. Reporting, Andre mentioned, it's really good for summarizing. When you give it a circumscribed amount of information, great at summarizing. We think it's got a lot of applications there. And also for some invoice review, we think it's got some pretty decent applications. There's a number of other things that we're working on. And I think we've always found when you've got a new tool or a new technology, the first thing you try to do is apply it to things that you've done before. But a lot of times the coolest applications are things you haven't been able to do before and only are possible through the technology. And I think we're just going through all the things we're trying to use it for that we have done before. We've got some ideas for things that we've never been able to do before because of cost, that don't require exactitudes, but bring a lot of value to customers and clients. And so we're working on those. Next slide. Yeah, so I mean, basically, what we're hoping to do, and we've been working on this like all year. We started really early in the year, working with a partner that's been fantastic and developed the system that we use. But we're just trying to use every means we can to be more efficient and productive for our clients, get our costs down wherever we can, get better quality output, and maybe even make it a little easier for the attorneys and staff to do their jobs, because we're all under a lot of pressure. But one thing I can just summarize is this is a tool that you cannot give to inexperienced people, because it can suggest a lot of things that are wrong. You have to be able to understand exactly what it's telling you and judge it for whether it's good or bad, and be very judicious in its use. With that, I will turn it over to the next speaker. Thank you.
Yeah, I think I just have a couple comments on contract uses. I will say, Steve, Anna Maria used two terms, coherent output and hallucinations. So I think it does a really good job with coherent hallucinations at times. So you definitely need somebody with experience to look at the output, a human in the loop, as Andre had said. And that's the same true with contracts and their use cases. We've got a little less experience here than the uses for prosecution. Just in terms of volume, we do more prosecution, but it's of some value for helping draft contracts or reviewing legal issues that relate to contracts. Similar to what Andre said, it's very quick and can provide a long list of suggestions, but many you have to weed out. But every now and then you'll find a few that are helpful, and those kind of lead to some further iteration and maybe an improvement in the work product. If you're an experienced drafter, customary terms and provisions like confidentiality, limitations of liability, indemnification, go to your database of contracts, grab that, modify it as you need. You're going to do better kind of doing that on your own with some modifications versus letting AI do that from scratch. But if you've got like a unique term, AI can be helpful in sort of if you give it a good prompt, it'll give you something to work with to start. So it kind of gets that momentum going. So it does add some value there. And again, we haven't specifically trained our tool yet on like a contract database. So, these are only going to get better in that regard. So I'll leave it there for use cases. I mean, we do have other use cases, but we're running out of time. I'm going to turn it over to Alexis now, who's just going to wrap up with some guardrail discussion.
Thanks, Tyler. As we all know, generative AI is incredibly promising technology that will help drive innovation and creativity across many industries in the near future. However, with any new technology, there are always important legal considerations that we must keep in mind in order to protect the interests of our firms and our clients. I want to focus on the GenAI considerations in two key areas: first, patents, and then copyrights. On the next slide, we see some considerations that could be practical patent guidelines or safeguards. We need to make sure that as a community and for our individual clients, we are proactively filing patents to protect core AI innovations. But at the same time, companies should consider implementing human review of any generative AI output before commercial use in order to screen for potential patent or copyright infringement issues, as well as considerations on your terms of service. Anything can be considered, but explaining your use of AI to the users upfront on your websites may be something that's important. Other best practices to consider include possibly watermarking or fingerprinting your AI output, maintaining detailed documentation, using plagiarism detection tools, and, as you keep hearing, always having a human in the loop. On the next slide, we move into copyrights. And as a company or firm, guardrail considerations on the copyright side of things can be different depending on the use of GenAI at your individual company and even in departments of your company. Some considerations to include into guardrails or safeguards for your use of GenAI are proper attribution whenever GenAI is incorporated into a company's output or product, or whether it's trained on copyrighted data. Consider whether having a DMCA takedown notice process to address any alleged allegations of infringement, as well as obtaining licenses or indemnity for training data, can further limit risks when using GenAI. Additionally, companies may consider using federated learning and limiting employee data access to help obscure source training data as a form of trade secret protection. Screening for open source code and implementing audits provides oversight, as well as, of course, always using AI output as a starting point for human creativity, whether that's in writing patents at a patent firm or writing code as one of our clients. Working closely with your in-house or outside counsel to discuss the best GenAI guardrail considerations for your company is a great place to start. And it's going to be an ongoing conversation. On this last slide here, we have a list of some of the rules and regulations. Next slide, please. And effectively, that means there are no current rules or regulations in the US. Places to keep looking for are USPTO guidelines, which we should be expecting in the next few months. They had put out written discussion and requests for comments, which you can listen to at some of these links. There's also the ongoing need to always follow case law. Right now, primarily, we have copyright case law coming out with one Supreme Court decision on fair use, but this will be ever changing and most likely change our intellectual property law as we know them. Below are a couple relevant government discussions on AI risk management, and of course, President Biden's executive order issued last week. We'll be finding out from government agencies in the next few months how they're planning on addressing safety and trustworthiness of artificial intelligence. Thank you very much for attending today. I think Tyler will wrap us up.
Yeah, I think, thank you, Alexis. We're over our time limit now, and I think we got to a few of the questions that were answered online. I just want to thank everyone for joining. Our plan is to have a few more generative AI related webinars in the future. This is a pretty developing area, so hopefully you all can join us at a later time as well. Thank you.